Hello, Dean Schwimmer here. Welcome to today's vlog. Today is going to be one of those rare occasions where I reply to a commenter. I'm recording this on Tuesday. You're seeing it on Wednesday. So Tuesday morning, I got a comment, or I saw a comment. I first need to give you my policy regarding comments, because I'm only human. I may slip up, so I want to give you my policy, which is not to debate commenters. The reason I don't debate commenters is because I don't think it's fair. I have my whole vlog to state my opinion, so if somebody has an opposing opinion, my policy is to let it stand, because I don't think it would be fair, because somebody could write a short comment and then I could talk about it for as many vlogs as I want, for as much time as I want. What I would like to see, it would be nice someday, maybe when I have more subscribers, more viewers, would be all of you to get into a debate. If a commenter post a certain comment and somebody has an opposing view, to post their own comment, and then there would be a debate. When I do, on rare occasions, jump in to reply to a commenter, it's because of one of two things, sometimes both. It's either because or that a commenter missed an important point that I think should be noted, so I'll note what I think the commenter missed. And also sometimes the commenter raises an interesting issue that I want to talk about. So that's what happened today. The comment came from Arussa. I hope I'm pronouncing that right. Arussa, A-R-U-S-S-A. I'm not going to read the whole comment because it's quite lengthy, but you can go into the comments section below the video and you can read it for yourself. Well, first of all, I have to say there's a little bit of hypocrisy here, or, well, maybe not hypocrisy, maybe that's the wrong word, but I've heard from Joe Biden and other Democrats, well, the election is over, just suck it up, let's all get along, let's work together for the good of the country, and let bygones be bygones. I'm going to talk more about that in a future vlog. What I want to get to now is that in Arussa's comment, I just noted a very condescending tone, and my just suggestion is, if that's what you want, if you want unity, if you want us to come together, that you should be more respectful of people who disagree with you, not consider them to be ignorant or rubes or stupid or overly partisan. They are reasonable, intelligent people who are making a point. And even if you think they are not reasonable, intelligent people making a point, because reasonable people can look at the same set of facts and reach different conclusions. It's nothing unusual about that, but even if you think somebody is, well, if I think somebody is a complete idiot, I still treat them with respect. Because if you want unity, if you want us all to get along, then you need to be respectful to people, even if you think they're stupid, and just make a reasonable, calm rebuttal or argument. So that's just my suggestion. Of course, you don't have to take it, Arussa, but I think your whole Democratic Party, you're obviously a Democrat or a liberal. I have to assume that from what I'm reading here. So I would just say that if that's your goal, to get along, then be more respectful. I guess that's all I'm saying. So what I want to get to here is, Arussa starts out, he's talking about the two Giuliani hearings, the hearings in Pennsylvania and Arizona. These were informal hearings. They were not official hearings, but there was one today in Michigan that I'm going to get to a little bit later. But the two hearings that have happened so far, they were unofficial. They were held by state senators, but they were not in the Senate. And as Arussa correctly points out, none of these people who testified were under oath. But what Arussa misses, all of these people who testified, all these witnesses, they had submitted written affidavits that were sworn under oath, penalty of perjury. They all made good faith affidavits under penalty of perjury. So you have to keep that in mind. But also what I think Arusa is missing, it's one thing, which is what Arusa seems to be implying, that these people went deliberately to make charges not under oath, and then they don't want to testify under oath. They're trying to pull some kind of trick, but it was clear from the testimony. And I should mention here, I'm one of those, I guess if you can call me lucky, I have a home office. I work from home. I'm a real estate broker. Most of my time is on the internet. Sometimes I'm on the phone a little bit. Most of the time I'm doing research, scouting locations, writing emails, so I can keep a hearing on all day, and that's what I did. The Pennsylvania hearing started at 9 a.m. in the morning and went into the, I'd say about 7 o'clock in the evening, maybe later. I listened to the whole thing. And the Arizona hearing, I listened to the whole thing. I was able to hear altogether probably hundreds of witnesses, and I haven't gotten to Michigan yet, which happened today. I will get to that. But the point I'm making here is these people want to testify under oath. That is the problem. This is another point that I think Arusa is missing, which is that these courts, well, said, I don't know if it's a he or a she, I'll just stick with Arusa. Arusa says the courts have already decided that there is no significant voter fraud anywhere. That's factually false, because first of all, there are still appeals being done. There are cases that have not been heard in Michigan, Wisconsin. You still have, well, the ultimate decider will be the Supreme Court. Until the Supreme Court, if it gets that, it'll go to the Supreme Court. Either they will just not hear the case, they won't grant cert, as they say, then it would end right there, and then you could say that there has been no finding, perhaps. If there is a court case then in the Supreme Court, then you would definitively have an answer. But I think that Arusa has not looked closely at the specific cases. So we'll just take two. The Third Circuit did not rule on the, well, what the Third Circuit said was that they're a federal court and the election is governed by Pennsylvania. This isn't Pennsylvania, the Pennsylvania State Court. And they said there was no evidence of a federal crime. That's all they said. They didn't rule on the merits of the state case. And then in the Pennsylvania courts, the state courts, they did not rule on the evidence either. That is a whole point. They did not allow the Giuliani team to present any evidence. They just dismissed the case, which, by the way, as I understand it, a lawyer can correct me, under the rules of evidence, if somebody seeks to dismiss a suit, the court is required to take the evidence and give it the interpretation most favorable to the side that's being moved against which is being sought the dismissal. So the court did not even hear the evidence. But the issue in the state court is that the state law of Pennsylvania and Arizona were very specific that each ballot had to be opened and counted in front of an observer from any political party that wanted to observe. So a Democrat and a Republican, and if necessary, independent. That was not done. What the Pennsylvania court ruled was that that was okay. That's why this is going up eventually to the Supreme Court. The point being that nothing has already been decided. And let's go over to Georgia. Georgia, the Sidney Powell suit wants to examine and do a forensic examination of some of the Dominion voting machines. They were about to be wiped clean, and then it would be impossible. A judge issued an order to keep the machines as they are. Then the judge changed his mind and said it was okay to wipe the machines. Then the judge changed his mind again and said, no, maintain the machines. And if we're talking about Georgia, I want to show you this headline here, because this gets to this point about, well, there's no evidence and the courts have already decided, so on and so forth. Here's this headline: Georgia eyes more than 250 investigations of, quote, credible claims of illegal voting and violation of state election law, unquote. And I want to bring up another point, this idea of there not being any evidence. I'm going to show you a graphic now. Now, this is from the Michigan hearing today, which, by the way, did not include any participation of Rudy Giuliani or the whole team. This was held by the Michigan State Senate Committee on Oversight. I've been watching it all day. It's been going on. It's still going on as I'm recording this, as a matter of fact, but I have to go and do something else, unfortunately. But this was a point that a mathematician, an expert, brought up in the Arizona hearing. I was not able to capture that chart, but I did today. I was able to act quickly with my snippet tool on my computer and get a screenshot. So this was a point that was brought up about the integrity of these machines. Now, first of all, these Dominion machines, they're supposed to only tabulate. They're not supposed to calculate. They're only supposed to count votes. Now, here is the screenshot from the hearing. Well, you can see the last two columns, but this particular witness circled the last part of the second to last column, the penultimate column. You can see this first number, 1,925,865.66 votes. Second line, 1,930,247.684 votes. The question that was raised, it should be an obvious question. You're counting voters. There's no fraction of a person. So the first question that this mathematician, whose credentials, this person was very, very well qualified to opine on this, and he asked first this obvious question: why is this voting machine printing out decimal numbers? It should only be whole integers. 1,000 votes, 1 million votes, an integer. There should not be any decimal point. And here you have these numbers going out to 2 and 3 decimal points. That was an obvious question. Why is that? So the point is that this idea that there is no evidence, that there's nothing wrong, I just gave you two examples right there. But you have, out of the time I've been listening over the last 3 days, hundreds of witnesses coming forward testifying about written affidavits under oath. And the point being, out of all that, I heard only one witness that said anything that was even remotely favorable to the election being run legitimately and there being no fraud. So where were the other witnesses? And that one witness was today in Michigan, and it was just saying that, well, it's the state of Michigan's fault. They didn't give enough people. I thought people were working hard or whatever. But you had hundreds of witnesses saying that they were just thrown out of there. And you can see on YouTube a video of people, the poll workers in Detroit, applauding and cheering as a Republican was led out of there. There were virtually no Republicans, and every time a Republican challenged a ballot, they were dragged out of there. They called the police and they were taken out of there. That happened. There were so many witnesses to this, and this would be my advice to Rusa. I wonder how much of this hearing you actually watched. That's one of the points, the problems that I have, is because I'm able to hear and watch the entire hearing, and then I look at the news and I see that it's not being reported. They're just saying this over and over and over. There's no evidence. There's no evidence. Never mind Georgia, 250 investigations. So we'll see how it turns out. I just wanted to, like I said, if Arusa thinks that it's, what was Arusa's term? That it's, that it was fake, it was not a true hearing. Well, the reason for the hearing, the two Giuliani hearings, was not the Michigan one, because that actually is being held in front of a committee, an official committee of the Senate, but the reason for those hearings was to get the legislatures to listen to the evidence. That's all they're asking for. Let us testify under oath. That's where I think that Arusa's missing again. They want to testify under oath, and however much we might disagree on this or that, I would hope that Arusa and I would agree that they should be allowed to testify, and not only allowed to testify, but they would be, well, of course, there would be Democrats and Republicans in the Senate committee, and all of these witnesses could be cross-examined. They would be, I would imagine, quite hostile questions. That's what I saw in Michigan. You saw, just today, you saw witnesses in front of a Senate committee. There were Republicans and Democrats, and they both asked questions, and the Democrats asked some very tough questions that, to their credit, these witnesses were all able to answer. But the question is, why would anybody not want this evidence to be heard? So I am hopeful that it would be, and we'll see what happens. It looks like it's moving forward in Pennsylvania and Arizona. After they got to hear the evidence that the courts refused to listen to, they are trying to hold back on the certification. I'm not 100% sure of Arizona. That's still in process, but because the hearing was so recent. But in Pennsylvania, definitely they are moving forward, which is all that the Giuliani team is asking for. Do not certify until you hear the evidence. I would mention one other point about the Arizona hearing. A computer expert was asked, if you could have access to the voting machines, how long would it take you to do a forensic analysis? He said 4 days. There was another witness that testified that a group had traced voters to addresses that turned out to be parking lots and churches. They took a sample. They were able to do 30,000 voters out of, I think, 170,000. They were asked, how long would it take to look at all of these? They said we could do it in a week, in 7 days. We could do it. So why not give them time to do it? Because the drop dead date, or the safe harbor date, is not till December 8th. And this gets to a final point that I think Arusa, and by the way, I'm linking to all this stuff here, by the way, that I'm going to talk about right now. But Arusa said that if the state sends 2 slates of electors, that the governor, the slate selected by the governor, would be the one that the Senate would accept. That is based on this, counting electoral votes, an overview of procedures at the joint session, including objections by members of Congress, Congressional Research Service. So first of all, this is an opinion by 2 lawyers. That's all it is, an opinion. But I just want to get in, I hope I won't bore anybody with the details, but well, the problem I had, Arusa, is you referred me to page 11. This document only goes up to page 9, and page 9 is just a contact, where to contact the attorneys. So there is no page 11. So I had to take a guess. Maybe you just physically counted the actual pages and got to the 11th page. I don't know. It's page 8 that I'm looking at of the document. But it's called Receipt of 2 Certificates from the Same State. I'm guessing that's what you're referring to. That's the section that you wanted to talk about. So, first of all, there is there's no real precedent for what would happen, but this section lists 3 situations, 3 instances, as the document says, where there could be 2 lists. Now, first of all, what you have to be aware of is, as it says right here, in the first instance, 2 lists would be proffered, but the assumption presented in the law is that only 1 list would be from electors who were determined to be appointed pursuant to the state election contest statute as provided for in 3 U.S. Code Section 5. So I have to wonder if Arusa read the 3 U.S. Code Section 5. Well, I did. So what it is that if the state shall have provided by laws enacted, I'll just summarize. What it's saying is that the state, if the state, and so we don't really know, I haven't researched this, maybe somebody out there wants to, but if the state has a law on the books about how to handle contested slates of electors, that controls, that ends it right there. If they have a law, so I don't know if Pennsylvania does or not, but also it says here, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors. Such determination shall be conclusive. That's what it says. So the date of the meeting is December 14th. That is when the House meets to count the electoral votes. So 6 days before that, that's the safe harbor, what's called the safe harbor date, December 8th. So Pennsylvania, any state, they have until December 8th to pass a law to decide how to deal with these electors. So as I read it, and I could be wrong, but that's how I read it. Then in the second case, when 2 lists are proffered as being from 2 different state authorities who arguably made determinations provided for, again, under 3 U.S.C. Section 5. So what they're saying, if I guess the law is so ambiguous in Pennsylvania that it allows for 2 different parts of the state government to, well, let's say if it allows for the state to select electors and for the governor to select electors or something like that, if there's some official way, then that leads to the second situation. And then winner of the state, the question which is the lawful to make the decision shall be decided, and this is the thing, it's decided by the agreement of both houses, the House and the Senate. So that covers that second situation. And the third instance, if there is no determination, if they don't send any slate of electors, the state doesn't, then again, the House and the state have to agree on which electors would be the ones that would be counted. But again, we haven't even gotten to that point. We have to see what the state does, because they can also just refuse to certify, and then you would have no electors. But we get to this governor thing, and Arusa is treating this as definitive, but there is, well, it says right here on the very next page, page 9, which I guess would be page 12 according to Arusa, precedent subsequent to the statute's original enactment in 1877 has been sparse. There appears to have only been one example, and pay attention to this example. In 1961, when the governor of the state of Hawaii first certified the electors of Vice President Richard M. Nixon as having been appointed, and then, due to a recount which determined that John F. Kennedy had won, they certified Kennedy as the winner. What happened was here was, well, it says right here, the presiding officer, that is the president of the Senate, Vice President Nixon, because he was the vice president at that time under Eisenhower, the president in office when the election occurred, suggested Vice President Nixon, which is to his credit, by the way, Nixon, suggested, quote, without the intent of establishing a precedent, unquote, that the latter and more recent certification of Senator Kennedy be accepted so as, quote, not to delay the further count of electoral votes, unquote. This was agreed by unanimous consent. So the point being that this is a case where the governor had appointed the electors, but a recount showed that the other candidate had won, and the governor's electors said that they would vote for Nixon. The recount said that it would be Kennedy, and they went with Kennedy. They did not go with the governor. So in fairness, it says that they did not intend that to be a precedent, but it doesn't mean that they wouldn't go with the governor necessarily, but at least there's one example where they didn't. So we cannot say right now what would happen. So Arusa could be very well right. That's, in fairness, you could be right, but it's not as definitive as you're saying, and that's what I'm saying. I'm not debating with you. I'm not saying you're wrong. I'm just saying that you missed this, and I think you also missed the constitutional issue if this goes up to the Supreme Court, because the Constitution, Article 2, is very, very clear that the state legislature determines how to select the electors. That's very clear, and that has not been tested, except that in the 2000 election, that was one of the points that was made, Bush v. Gore, and for whatever reason, a couple of the liberal justices would not sign on to it, so it was a concurring opinion. But they made that same thing in Florida when the Florida Supreme Court stepped in and ordered recount after recount. The Supreme Court, these justices anyhow, I think there were like 4 of them, there were about 5 justices, so it was a majority decision anyhow, but the full decision was 7-2. But you had a majority that said that the state legislature alone has the sole power to determine the result of the election. So I hope I wasn't too hard on you, Arusa. Again, you're entitled to your own opinion. I just think that you missed some things. And then you can also rebut and say whatever you want in the comments. Again, I'm not going to disagree with you, but I think you have to take all of these things that I mentioned into consideration to be fair, which brings me now to the Michigan hearing that was today. Again, this had nothing to do with Rudy Giuliani, nothing to do with President Trump. It was brought by voters in Michigan, by poll watchers, or as they called them, at least in Michigan, poll challengers. You had witness after witness after witness testifying how they were thrown out of there. How they were mistreated, how they were told to ordered to stand 6 feet away, while the Democratic observers were able to sit right at the table and even sometimes helped count the ballots. They talked about really not being able to see anything, not being allowed to see anything, about being insulted, about being dragged out, and people cheering. But it wasn't just 1 or 2 witnesses, it was witness after witness after witness after witness. And what are they asking for, all these witnesses? Just not to certify the results, not to send the electors until these allegations can be investigated, which is very simple. If somebody swears under oath, penalty of perjury, that they were mistreated by a certain poll worker, well, you can... First of all, even if these people are pulling something and they don't want to testify under oath, they can be subpoenaed and made to testify under oath. So there is no way to get out of it. They surely understood that even if they didn't want to testify, they could be made to testify. But you also have the opportunity to cross-examine, but you also have the opportunity to bring in these supposed infringers and harassers and people miscounting ballots. You can bring in, for instance, several witnesses testified to ballots, the place being almost empty, the ballots having been counted, and then suddenly 50 boxes of about 5,000 ballots in each box brought in at 4:30 in the morning, no chain of custody. Well, you can investigate, where did those ballots come from? You could question the people who brought those ballots in. Where did you get them? You can look at the ballots. There was one person who testified that she could see that this was in Arizona, that she could see that signatures were not matching. There would be a signature on the rolls and then just a quick, chicken scratch on the actual ballot. Well, those ballots are there. You can look at them. Why not look at them? If you have somebody in Michigan saying that they were mistreated, they were not allowed to watch, and they gave names. So they said, one witness say, Mr. Baxter, the leader of this particular counting table, would not let me observe. Okay, well, bring in Mr. Baxter, put him under oath, ask him, did you or did you not allow this person to observe? There is security camera footage all over the place of these counting centers where you can clearly see that there are not two observers, a Democrat and a Republican, and it should be possibly even more like an independent or a Green Party. They were not watching. You can see that they're counting all by themselves with nobody standing behind watching. You can all see that. And this brings us back to the problem of the state courts in Pennsylvania, anyhow, where they ruled, even though Pennsylvania law required signature verification, the Secretary of State said, no, you don't have to verify signatures. And the Supreme Court of Pennsylvania, the Pennsylvania court, not the Supreme Court of the United States, said that was okay. They said it was okay not to obey the law, which is another subject for another day. This problem of having clearly written laws and then having a court say, well, no, you don't have to obey the law. So we'll have to see what happens, but that's 3 states now: Pennsylvania, Arizona, and now Michigan. And then you have Georgia, 250 so far, allegations being investigated, so on and so forth. It's not over until December 14th, and even then it may not be over. By the way, there is a constitutional solution. The Constitution covers this. If there is no president designated, if they don't have a winner by January 20th, then Nancy Pelosi. I can say as a conservative, I would not be very happy about that, but I would accept it because that's what the Constitution requires. That's what's in the Constitution. Nancy Pelosi would become the President of the United States until an actual presidential winner could be determined. So this has been a long vlog. I'm going to just leave it there. I'm just going to say that especially, I always say I appreciate the time that you spend with me. I really appreciated it today because I really went on and on and on. Well, I hate to do this because I know I've been talking for quite a long time today, but there are a couple of loose ends I just remembered that I should tie up just to be thorough. So the first one is that I mentioned Georgia, 250 credible allegations being investigated. I showed you that chart from Michigan of the fractional votes. What I forgot to mention about Pennsylvania was that these universal mail-in ballots, 1.8 million ballots were sent out. 2.5 million ballots came back. In other words, the state got back 700,000 more ballots than they sent out. So what explains those ballots? The obvious explanation is that they're manufactured fake ballots. But my only point is that, maybe there's some other explanation, but the thing is that they should be investigated. That should be investigated before you send the electors if you want to have an honest election, which is a point that one of the Michiganders made. That's a native of Michigan. I'm a Michigander myself, by the way, originally from Michigan. So they're saying if you want us to come together and have faith in the election, then you should have no objection to having all these problems investigated and just determine one way or the other. Look at the voting machines, look at the ballots, look at the signatures. Why not, if you're not afraid of anything? So just my own personal opinion, I think they are afraid of something, that they know that there was fraud involved. In my personal opinion, others can disagree, that was the whole point of these mass mailing of ballots. The whole coronavirus, that's just a canard. They wanted all these ballots out here because, as no less persons than James Baker, former Secretary of State and Secretary of Treasury, and former President Jimmy Carter, they did a study on this, and they said, they talked about how susceptible to fraud mail-in ballots are. And just a final point that I forgot to mention, because Arusa talks about that the Pennsylvania legislature, do they want to commit political suicide by thwarting the will of the people? That was the phrase that Arusa used, and sending their own slate of electors. Well, if you're talking about fraud, if there are all these illegal votes, they don't count. Their will doesn't matter. If the will of the people, if the legal votes are for or were for Trump, then if they certify electors for Trump, then they are obeying the will of the people. But as Giuliani himself made the point at the Arizona hearing, that if you lose, so what? I mean, there's something that's more important. You have to do the right thing. If you think that the election is rife with fraud, and it was clear that the Arizona senators thought there was, then you have to, you can't let a fraudulent election, you can't send a fraudulent slate of electors. And which I guess is a final point that I'll have to make, is that why were there no Democrats at this hearing? They were welcome to come and produce their own witnesses, and I think it's because they're trying to bury this whole thing. Just like I don't think this is getting reported in the media. I know because I listen to the entire hearings, and then I go on, to the news to read about it, and I see nothing. I see nothing, and I think they're just trying to bury it. That's what I think. But you can't bury if a state refuses to certify their election, or send a slate of electors, or send a different slate of electors. And they can then be, as Arusa said, be held accountable by the voters. They'll just be thrown out, and somebody else will be elected if they are angry or disappointed or oppose what the legislature does. So I'm just going to end here. Thanks for spending time with me. I know it was a lot of time today, so maybe some of you are asleep by now, but anybody who was with me still, I really do appreciate that you spent the time with me. I hope you got something out of it. I also, if you can spare a little more time, I would love to get a thumbs up if you like this video. Share with anybody you think would also like the video. Got any comments? You can put comments in, as Arusa did, in the comment section below the video. You can also put questions, suggestions for future topics. You could visit my music channel and listen to my original music. There's going to be another song up there pretty soon. But what's up there now is really good, and I put a link in there. It's under my name, Gene Allan, my music name, so people looking for music don't stumble on my political opinions. I'm not Barbara Streisand. I separate my music from my politics. And I guess finally, just, subscribe. I love getting subscribers. But most of all, come back and see me again. I look forward to seeing all of you again. And until I do see all of you again, bye.